commercial lease lockout for unpaid rent can have serious consequences for both landlords and tenants. But a landlord cannot simply change the locks whenever rent falls into arrears. The right to lock a tenant out depends on the lease, the Property Law Act 2023, and strict compliance with required legal procedures. Non-payment of rent is one of the most common breaches of a commercial lease, but it doesn't automatically entitle the landlord to re-enter the premises. In most cases, the landlord must first establish that the lease grants a right of re-entry, serve any required breach notice, allow a reasonable opportunity to remedy the default where required by law, and comply with the procedural requirements before exercising the right of forfeiture. A lockout that occurs without following these steps may itself be unlawful and expose the landlord to significant liability. For tenants, receiving a breach notice does not necessarily mean the lease is over. Paying the outstanding rent within the required time frame, negotiating a repayment arrangement, or otherwise remedying the breach may prevent the landlord from exercising its right of re-entry. Even after a lockout has occurred, tenants may, in some circumstances, be able to seek relief against forfeiture, allowing the court to restore possession where it is just to do so. Whether that relief is given depends on the nature of the breach, the conduct of the parties, and the surrounding circumstances. Landlords should also exercise caution before changing the locks. Wrongfully excluding a tenant from the premises can expose the landlord to claims for damages, loss of business, and legal costs. Simply because rent is overdue does not mean every procedural requirement has been satisfied, and acting prematurely may significantly weaken the landlord's legal position. Equally, tenants should not assume that remaining in possession without paying rent is a viable long-term strategy, as continued default may ultimately result in lawful forfeiture, termination of the lease, and substantial claims for unpaid rent, damages, or other losses. Because commercial lease lockouts involve an interaction between contractual rights, statutory requirements, and equitable principles, determining whether a landlord can lawfully change the locks often requires careful analysis of the lease, the notices served, and the steps taken before re-entry. Acting too quickly, whether by locking a tenant out or assuming a lockout is automatically valid, can have significant legal and financial consequences for both parties. Contact us today for a free 30-minute consultation with one of our experienced team of commercial lease dispute professionals, and let us help you protect your rights.